Hello, law students and legal practitioners. Today, we will analyze the case of Angobung versus Commission on Elections, GR number 126576, decided by the Supreme Court on March 5, 1997. Let's begin. Here are the legal doctrines of the case. The power of recall is an incident of the people's sovereignty and must be strictly exercised in accordance with statutory requirements. While recall is intended to be a direct remedy of the people to remove officials who have lost their confidence, such power cannot be used to destabilize local governance through procedural shortcuts or circumvention of the law. Under Section 69(d) of the Local Government Code of 1991, a recall may be validly initiated only by a petition of at least 25% of the total number of registered voters in the local government unit concerned. This requirement is mandatory and jurisdictional, designed to ensure that recall proceedings reflect the collective will of a substantial portion of the electorate, and not the grievance of a single individual or a minority faction. The phrase, petition of at least 25%, means that the recall petition must be initiated by at least 25% of the registered voters, not merely signed later by such percentage after being filed by one person. The law does not allow the filing of an initiatory recall petition by only one registered voter, as this would render the statutory voter percentage requirement meaningless and invite abuse of the recall process. Recall elections must be guarded against misuse. Lawmakers deliberately imposed minimum voter percentages and time bars to prevent frivolous, harassing, and destabilizing recall attempts that could disrupt governance and undermine the stability of democratically elected institutions. Here are the relevant facts of the case. Petitioner Ricardo M. Angobung was duly elected mayor of Tumaini, Isabela in the 1995 local elections, receiving approximately 55% of the votes cast. Private respondent Addie Aurora S. de Alban, who was also a candidate in the same election, later sought petitioner's recall. In early September 1996, private respondent filed a petition for recall with the local election registrar of Tumaini. The petition was signed only by private respondent herself, without the participation, joinder, or identification of at least 25% of the registered voters. The petition was thereafter forwarded to the Comelec for approval. Acting on a memorandum from the Deputy Executive Director for Operations, the Comelec and Bank approved the recall petition and issued Resolution No. 96/2951, which authorized the further signing of the petition by voters and scheduled a recall election should the 25% threshold later be met. Petitioner challenged the resolution before the Supreme Court, arguing that the recall petition was void for having been initiated by only one voter in violation of Section 69(d) of the Local Government Code, and the recall election allegedly violated the one-year statutory bar. A temporary restraining order was issued by the court. While the court ruled that the one-year bar was inapplicable pursuant to Paris v. Comelec, it found grave and fatal defects in the manner by which the recall process was initiated. Issue 1. Whether a recall petition signed and initiated by only one registered voter validly initiates recall proceedings under the Local Government Code of 1991. No, a recall petition initiated by only one voter is void. Section 69(d) of the Local Government Code unequivocally requires that recall be initiated by a petition of at least 25% of the registered voters. This is a substantive requirement designed to prevent frivolous and harassing recall attempts and to ensure that recall reflects a serious and collective judgment of the electorate. The court held that allowing the recall petition to be initiated by a single individual would effectively emasculate the statutory requirement and allow recall to be misused by disgruntled election losers or political opportunists. Private respondent's petition, lacking the participation of the required 25% of voters at the initiation stage, was therefore patently invalid. Issue 2. Whether Comelec Resolution No. 96/2951 approving the recall petition was valid. No, the Comelec committed grave abuse of discretion. Administrative agencies such as the Comelec cannot amend, dilute, or circumvent explicit statutory requirements under the guise of rule-making or procedural implementation. The 25% voter requirement for initiating recall is fixed by law and cannot be altered by administrative resolution. By approving a recall petition filed by only one voter and merely inviting other voters to sign later, Comelec sanctioned a procedure that directly contravened the Local Government Code. This amounted to grave abuse of discretion and rendered Resolution No. 96/2951 null and void. Thank you for listening and happy learning. Please don't forget to subscribe to the Legal Shepherd PH YouTube channel and click the notification bell to stay updated on newly uploaded cases and jurisprudence. See you again for our next case discussions.